I may be pardoned, my lord. I may be pardoned, my lord.
Please wait, please wait. Yes. And, yesterday when I have mentioned item 246 matter of CBI, Sathana Japan CBI, as I have given the copy email to him. He called me the orders
Oh, where is he?
and I have he's not picking up the telephone when I given the WhatsApp message to him.
What can I do?
Unless
Unless he appears, no. Unless he appears, I can take up this matter. We'll see. You try to contact him if it is possible. At any time, we can come and
4 o'clock my lord, possible.
Okay. Yes.
Bless.
Lance case, my lord, 2015 matter for hearing, my lord.
Paper book ready.
Beg pardon.
Paper book ready.
Sorry, my lord, I have not verified, man.
So plus verify. If it is ready, then why are you mentioning? It is ready. Yes.
Modification of order.
Please give it.
Tomorrow, my lord.
It will come. Give it.
One item not pressed.
Which one?
Weekly list item number 168.
168.
168. My lord.
That is BLAPL number 11692
My lord.
of 22.
22.
All right. You are filing a memo? Land Council for the. Okay. Not pressed. Yes, sir.
And one matter there in the list, weekly list for yesterday today, item 181, my lord.
Yes.
That custody report has come, but the IA which I have filed for bail that has not come. May I make a small request to call this matter Monday along with that IA?
What is that IA number?
1865 of 2023.
1865 of 2023.
Yes, my lord. He is already in custody for 8 years out of
this application is for bail, that IA.
Yes, my lord.
All right. Mr. Mahapatra and counsel for the appellant submits that an interim application by IA number 1865 of 2023 has been filed for bail. Release this matter in the week commencing from 21st of August 2023 with IA number 1865 of 2023. That is item number 181, CRL number 423 of 2016.
May I make a small play for Monday because already 8 years out of 10 years is in custody.
Next week, 15th is a holiday. So we do not know what would be the position. So you have to wait for one more week. Yes.
I may be pardoned, my lord.
Yeah.
Item number 3 of today's supplementary list and item number 36 of the weekly list. May I pray to take those matters in the week commencing from 28. I am suffering from fever, cold, severe cold and cough, my lord.
Item number?
Item number 3, today's list supplementary.
3, it is
list and item number 36.
Mr. S.S. Das, senior advocate, is there, Mr.
Yes, my lord, I am suffering from high fever. Since yesterday, I am not slept.
Okay, I will accommodate you, but in his presence, please wait when the matter is.
I will intimate, my lord. I will intimate him. So I am unable to see it, my lord.
Okay. This matter will be taken up at 2 p.m. That is the noting. So please intimate him so that let him come and I have no objection if it is taken up next week. There is no problem. I know that you are in difficulty. There would be no problem, but just ask him that I have made a mention and
yes, my lord. And
the court requires your presence. That's all that.
Yes, my lord. Item number 36 too. That is also for objection and hearing.
Okay, item number 36. All right.
Weekly. I have already filed the objection.
All right.
Oblige, my lord.
Weekly list item 36.
My lord, 36.
Yes.
Item 36, my lord.
He is not well. He is asking for time. And you have filed objection here, Mr. Das?
Yes, I have already filed. Objection is available before your lordship, and I have served the copy yesterday to Mr. Senior Counsel, Mr. Gautam Mishra, Judge Associate.
Okay.
Yesterday in your lordship's court, I served the copy.
Right. Item number 36. Mr. Sanjay Kumar Das, Standing Counsel for the Vigilance Department, submits that he has already filed objection to
On
the interim
Panchayat.
application.
On Panchayat.
Here, my lord, I am for the appellant.
He's not well today, so he wants.
Today, my lord, may fix a short date because
it will come. Okay, it will come on 21st, Mr. Mishra.
the person is still in service now.
No, it's all right, but 15th is a holiday. I will fix it on 22nd so that it will come in the supplemental list and
We have served depositions and all of them are
Alright.
part of it.
and he is further submit that he is not well and the matter will be taken off a week after. Mr. Mishra and senior advocate is present. On consensus of both the parties, list this matter on 22nd August 2023. Objection, if it is not available, be placed on record. Okay, it's all right.
Obliged, my lord, obliged.
And you remind this matter item number because Mr. S.S. Das is not here. So tell him that and place that matter also on that day. Okay. Yeah.
Supplementary list, item number 1.
May I please?
Yes.
Last time, after verifying the records, pursuant to my lord's direction, I have only flag marked the exhibits. Facts of the case is like this. The complaint is P.6. After judgment was pronounced, the complainant has filed a petition for release of cash and the gold ornaments. I'll kindly have glance to order dated 23/12/2016, passed by Learned Additional Session Judge Champua.
No, last time it was listed on 8th August 20.
My lord, my lord.
Petition under section 452 CRPC, my lord, was filed before the trial court after conclusion of trial, my lord. And it was read that the seized at currency notes, which was seized during course of investigation, be released in his favor, which was turned down, my lord. Against that order,
He at the time of pronouncement of the judgment, he did not pass any order so far as the properties are concerned.
No, judgment passed.
Because, my lord, the reason assigned, my lord. Reason is the other accused persons are still not arrested, my lord.
Okay.
And investigation is pending, my lord.
Where is that? Where is that line?
That is in the judgment, my lord. You'll also make a
No, judgment is here before me. Which paragraph it is stated?
the last paragraph.
Acha, no order is passed. All right. This one. Yellow. No order is passed regarding disposal of seized cash and properties since investigation of the case is open against other persons. So this judgment was pronounced on what date?
6th January 2016.
Date of judgment.
6/2016. Page 41.
6/1/2016.
My lord.
So thereafter, when you filed this 452 CRPC petition,
My lord.
yes.
After the judgment,
What is the date? Please tell me.
23/12/2016, order was passed.
I'm telling you, when you filed the petition under section 452.
No specific petition has been filed under section 452 CRPC, my lord. No specific petition.
Then?
5/12/2016, petition was filed.
5/12.
My lord.
2016.
My lord.
452 CRPC petition filed. When it was rejected?
On 23 12/2016.
So that order you are challenging here.
My lord.
All right. Let us see that what is your petition? Have you filed the copy of your
Yes, my
petition?
lord, I have filed copy.
That is at page main petition to there.
Subsequent case in file. As for the information of para 3,
Just a minute. I want to see that petition. You have a 452 petition ଅଛି ଦେଖିବ ନା ଆମ ଇଏଥିରେ ଅଛି ନା ନାହିଁ
memory file କରିଛି.
This petition is shown to have been filed on 9/12/2016 bill ଲେଖା ହେଇଛି ଏପଟେ but additional PP received it on 5/12 whatever it may be. So whether the state filed any objection to this petition?
No objection is filed.
Have you given a copy of
No.
surprising thing?
State से जो branch दिया है ता पूर्व दिया है.
No, court record ଅଛି.
That 452 state petition copy is not fixed.
नहीं से जो deposition copy देला सेते थिला से branch रे थिला.
It must be seen that what are the grounds you are taken in that 452 CRPC petition. Another thing, legal aspect is that suppose the court did not pass any order and he had given a reason that for this reason I am not passing the order under 452 CRPC. Whether a petition of this nature would be maintainable before the trial court after the pronouncement of the judgment, because that particular part is concerned, it has attained finality. So once the judgment is pronounced under section 362 CRPC, if he can only make the arithmetical error, if it is any, that can be corrected, cannot review that order. So once in that very judgment is it available? All right. It is the So that CRPC.
Section 452 CRPC clearly discloses that after conclusion of trial, this kind of petition can be filed. That is there.
452. Come to 452. That is the requirement on the part of a criminal court who is pronouncing the judgment after the trial, that when it is concluded, the court will make an order for disposal of the property, right?
Right.
Then.
But here in this case, my lord, it cannot be presumed that all the case is concluded, my lord.
No, that particular trial has concluded.
Particular trial in respect of some of the co-accused persons have been completed, my lord. But other co-accused persons are still not apprehended and investigation is still.
No, he has. That is one of the reasons he has assigned.
My
question is that suppose one particular case trial is concluded, court is passing an order that at this stage I am not going to pass any order for disposal of the property because of some reason, let us say. Can a 452 petition at the instance of the informant or any other person would be maintainable there before that court? Because particularly that part, if you file a petition under 452, he will pass another order. That means anything regarding disposal of the property, whether it will not change that very portion of that order where it is stated that no, I am not at this stage going to change the order.
Can I interrupt?
Yes.
I believe 452 doesn't contemplate a petition being filed.
No,
It's
that
the
is the
power of
required.
the court
Yes.
to pass
No,
orders.
here the court has said that I'm not, because of the co-accused persons are absconding, they are yet to be apprehended. Thereafter, he filed that 452. I'm asking that question to him that whether
order is itself appealable. So
no,
this is
if he reject his
applicable.
no, question is I'm asking you that whether in such a stage you could have filed a petition under 452 there, because if the court has power to deal with such petition, matter is different. But if he has no power after the pronouncement of the judgment, he becomes functus officio. Any change, if he makes in the operative portion, that would amount to review of that order. Maybe it is not a sentence part, it's not a conviction part, but this 452, he has given some observation. So once you file a petition there and insist the court or whatever may be, court passes any order, so that part order stands modified. That would be against 362.
That your lordship is right.
So see, that is why I'm asking you that how a 452 petition after the pronouncement of the judgment is maintainable in that court, which you have filed and order has been passed that no, I cannot, I have, that order must have been passed that I have already pronounced the judgment. It will amount to a review of the order. I think that is the order or anything
Yes,
else.
yes, ma'am.
So
That in view of the order already passed while delivering judgment in ST case.
right here, 362, he must have used that section 362 is a bar in that way. In the impugned order, you see, impugned order, has he not used that language? Are jota challenge korchindi ma apna.
There is no scope left to entertain such petition filed by the loan customer again for disposal of the cash seized in connection to the said case. Talk to it all, this court lacks jurisdiction to review its own order.
Right. But one thing, what you could have done, suppose he has not passed any order for this reason, you could have come against that particular order to this court. Suppose this court would have asked or might have interfered at that stage. But now you are coming, you have filed a petition under 452. Your application has been rejected and you are challenging that order. So the basis of the petition is that my 452 CRPC petition has been rejected. So my query is that, or my how a 452 petition would be maintainable. Once that is not maintainable, then the order passed is legal and justified. So where is the scope for interference?
I have given a decision last time.
I'm asking you, Mr. Panda, I'm asking you the legal point. Please try to research it. Okay. See that whether after the pronouncement of the judgment, if 452 CRPC petition is maintainable or not. So if not, your entire case goes, because your case is based, you are challenging a order, rejecting your 452 CRPC petition. And that 452 CRPC petition was filed before the Land and Trial Court after the pronouncement of the judgment. Simple thing. If you find a decision, please come ready. We'll take up this matter next week.
Next Wednesday.
All right. It's Wednesday mane kon? Next Wednesday.
16 तारीख.
But that is a hearing day. That's a jail criminal appeal are being heard on Wednesday and regular criminal appeals. So that can be taken off on 21st. We commencing from 21st.
So man, keep it on 22nd.
Okay, there is no problem. So take down that the petitioner has filed this petition and this appeal challenging the order dated 23/12/2016 passed by the learned Additional Session Judge Champua in ST case number 81 of 2013. That is annexure.
Now only judgment.
Huh?
Only the order has been punished. No index.
That in rejecting the petition filed by the appellant under section 452 CRPC. What is the prayer made in that 452 CRPC petition? Asha, to release the cash seized from the
Cash and property. Cash and property inquisition.
Cash and other properties seized from the possession of the accused persons during trial in favor of the appellant. It seems that the London trial court while pronouncing the judgment in ST case number 81 of 2013. Where is that judgment?
Page 41.
Okay.
2016. Page 41.
Okay. On 6/1/2016, conviction kale na acquittal kale?
Conviction kale.
Samastungu?
Aye.
Convicted all the accused persons under different offenses and passed an order that no order is passed, inverted comma bhitar rakh diyantu, is passed regarding disposal of seized cash and property, since investigation of the case is open against other accused persons. When a question is posed to the learned counsel for the appellant as to how, after the pronouncement of the judgment and order passed by the London trial court, that no order can be passed with respect to disposal of the seized cash and property, a 452 CRPC petition is maintainable as the court has become functus officio and in view of section 362 of CRPC, the court cannot alter or review that part of the order of the judgment, that part of the judgment. The London counsel for the appellant seeks some time to address the court and find out some citations on this aspect. List this matter on 22nd August 2023. The Mr. Mishra, this judgment was pronounced in 2016, right? And in the meantime, 7 years have passed. You also take instruction that whether the investigation of the case has been closed or not. Okay. The London counsel for the state shall obtain instruction in the meantime from the concerned police station That is police station eta.
Bambari police station.
Bambari police station. Acha. Inspector in charge of Bambari police station as to whether the investigation of Bambari PS case number 151 dated 7/9/2013 has been about the status of the investigation of so and so, which was pending as on the date of pronouncement of judgment in respect of the co-accused persons on 6/1/2016 in ST case number 42 of 2014. Stop. Free copy of the order be handed over to the Learned Counsel for the state.
Okay.
Mr. Mishra, you also find out if
Yes, yes,
any
sir.
decision contrary to that.
Item number 2,
my lord, your lordship already had this matter along with two appeal, my lord. In that case, my lord, bail has been granted to other co-accused. Since, my lord, the interim application was not there, my lord, in this appeal, this case was adjourned, my lord. Similar footing, my lord, your lordship granted bail to co-accused person.
No, in that case, the petitioner was on bail.
Yes, my lord. Here also, my lord, this petitioner was on bail, my lord, during trial.
During trial.
My lord.
So, Mr. Tripathi,
Yes, my lord.
these two persons, Binod Ataka and Purushoti Atka,
Yes.
who have been already released on bail, whether the appellant case is similarly situated. Appellant is one Ramo Ataka.
Ramo Ataka and Purushoti are same footing.
Better footing, my
Huh?
lord. Better footing.
Better footing.
Yes, Vinod was named by the eyewitness, but this person.
All right. The learned counsel for the petitioner submitted IA number. What is that IA? 1607 of 23. Submitted that এই যা ফার্স্ট ପ୍ୟାରାଗ୍ରାଫରେ ଲେଖା ହେଇଛି ସେୟା ଲେଖିଦେବେ। ମୁଁ ଏଇଟା ମାରି ଦଉଛି, ଏଇଟା ମୁଁ ଲେଖୁଛି ଆକୁ ତାର ଇଏ ଦଉଛି ଫାର୍ଷ୍ଟ ପାରା ହେଲା, ତା ନାଁ ଦେଉଛି, ଏତିକି ଯେତିକି ଅଛି କପି କରିବେ। He further submits ଗୋଟେ add କରିବେ that two of the co-accused persons, namely Urusati Ataka and Binod Ataka, who faced trial along with the petitioner and were for same charges and were also convicted under same offences, have been directed to be released on bail by this court in CRLA number 519 of 2023 and CRLA number 413 of 2023, both by order dated 11/7/2023. And the petitioner is similarly situated, and therefore the bail application of the petitioner may be favorably considered. Peruse the orders passed in respect of the co-accused persons in the aforesaid criminal appeals. Learned counsel for the state, ତାଙ୍କର ଯାହା ଲେଖା ହେଇଛି ସେକେଣ୍ଡ ପାରାଗ୍ରାଫରେ ଉଠେଇ ଦେବେ ହେଲା, ତାପରେ ଲେଖିବେ he further submits on verification of the case record that the petitioner is situated in a better footing than the co-accused persons who have been released on bail. ତାପରେ third paragraph ଟା copy କରି paste କରିବେ, but you just add that since similarly situated co-accused persons have been released on bail in criminal appeal, Baki, I am inclined to release it. Yes, allowed.
Fine of stay.
Stay relation of fines.
Item number 35.
And another defect is 7. 7 is code not furnished. So that advocate clerk welfare fees and this court fee you have paid.
Yes, welfare, advocate welfare fee has been paid.
Advocate welfare fee, it is how much amount you have paid?
10.
No, that is not advocate's welfare fee. That is advocate clerk's welfare fee is 10. High Court Bar Association fees is rupees 50.
Has been paid.
Where is the document? You have got proof any regarding ଆପଣ ପାଖରେ କିଛି ପ୍ରମାଣ ଅଛି କି ଆପଣ ପେମେଣ୍ଟ କରିଛନ୍ତି ବୋଲି ଇ କୋର୍ଟ ଫି?
ଓକାଲତଲା ମାରେ ଫିକ୍ସ ହେଇଛି ସାର୍, ସ୍କାନ କରି ପଠାଇ ଯାଇଛି ଅଲରେଡି।
ଏଇ ଦେଖିଲ ସ୍କାନ କରି କଣ ଅଛି 50 ଟଙ୍କା ମରା ହେଇଛି। Alright. The defect as pointed out by the stamp reporter has been removed. Now what is the this matter has been admitted or it is coming for the first time?
No, earlier it was posted, but the same content is due to some defects.
All right. Now what is the conviction and what is the sentence imposed?
The under section 13(1)(c) of PC Act, undergo RI for 2 years and 5,000 fine, and under section 409 IPC 1 year and 2,000 fine. And the appellant was on bail during the period
Just
of
2 years, 13(1)(c).
Yes, sir.
Fine is 5,000, then another 1 year under 409, and to pay a fine of rupees 2,000 and in defaults one. So it is to run concurrently. Okay. So that means you have sentence is 2 years, right? And you were on bail during trial.
Yes, sir.
Yes, Mr. Das.
My lord, I have already filed my appearance memo since 27/7.
27/7, okay. 2023. Hard admit call for the trial court record. IA 1242 of 2023. This is an application for bail. He was on bail, so bail allowed stay realization of fine. Pre-copy of the order be handed over to the Learned Standing Council for the Vigilance Department. After State of Orissa, the word vigilance shall be noted in the cause list as well as in the top of the brief henceforth.
My appearance memo 27/7 में भी
Learned Council Mr. Sanjay Kumar Das submit he has filed the appearance memo since 27/7/2023. Let the registry place the same on record and name of so-and-so shall be reflected. Mr. Sanjay Kumar Das be reflected in the cause list henceforth.
obliged, my lord.
deposition copy to be supplied. Usual order would have gone. Is there any fine amount here? They fill outside.
1 lakh. 1 lakh is there.
You have filed also an application for stay realization of fine,
No,
right? So these two applications will be considered after receipt of the trial court order and deposition copy to be supplied. Yes. So delay on loan and admit. Yes, next.
Item number 42.
May please, your lords. Let's see, kindly see page
What is the defect number 2?
Defect is copy not survey already served.
Defect number 2, 50 days delay. You have not gone through the stamp reporting's report.
Sorry, my lord.
So you file an IA for condonation of delay. It's a case of conviction.
No, my lord, it is a case of, my lord, the 454 appeal, my lord, against the disposal of property.
Right, you file first. Since there is delay of 50 days in filing this criminal appeal, learned counsel for the petitioner 6. Kete din darkar?
1 week time.
1 week time to file the interim application for condonation of delay. List this matter immediately after the IA is filed.
Blessed.
Item number 43.
May I please?
Thus, this particular item This Mr. Sanjay Kumar Das is not well today. He mentioned in the first hour and also intimated that he has informed you.
No, any ill health, I will not stand in the way. I only see because I had not brought the telephone to my mobile phone today. Now I find at 11:34 there is a WhatsApp message
Okay.
that he is suffering from fever at 11:34.
Okay, but he told me that he has already.
No. That is the only message to me, Milad, 11:34.
It's all right, but
I would have appreciated, Milad, if it could have been told to me before.
I said that. Why don't you? He said that I will.
No, I took an adjournment in NCLT because of that, because of this matter, Milad.
I told him that it is at 2 o'clock, but he said, of course, he was appearing to be in.
I'm not standing in the way in case of ill health, but would have been much fairer, Milad, if I had been informed before.
Let us make it on 22nd August then, because 15th. If we'll keep it on 14th, then there will be problem because it will go in. Nobody knows that where it will go. So if it is fixed to 22nd, it will come in the supplementary list like today.
As assisting lawyer will not be there on 22nd, Milad.
Then 29th.
Yes, for 29th.
Okay.
But I'm filing. I've served the copy of the written submission. I'm giving to your lordship my written submission and the citations.
Mr. Sauri Sundar Das, land senior advocate, appearing for the appellant, files the written note of submissions which are taken on record.
Along with the citations.
Along with the citations. And he submits that he will serve the.
I have already served.
Already served.
As directed by lordship earlier, Malad.
He has already served the same on the Mr. Sanjay Kumar Das, land and standing counsel for the vigilance. Mr. Das submitted during the first hour that he is not well. The matter may be taken off on some other day. The Mr. S.S. Das, land senior advocate, submitted that he got belated information in that respect. However, he submits that since the land and counsel for the vigilance department is not well, case may be taken up on some other day. Please this matter on 29th of August 2023 at 2 o'clock. Yes. 2. Okay. No. Yeah. Have you got any difficulty if it is taken up in the first hour at 10:30?
No issues, Brad.
Okay. So Khali chhadi diyan, 29th 8 it will come.
The only thing is that it may reach Finland because
that is why the problem is that if that election petition which is going on.
I have no issues, brother. It will adjust your lordship.
No. In supplementary list, maximum 3 to 4 matters are coming, so there will be no problem about it. Yes.
Weekly list item number 45.
accordingly. Yeah.
Item number 46.
Published.
Yes,
My lords, on behalf of Mr. Pand, I pray for next week.
next week, all right.
Publish. My lords, interim orders to continue.
What is this matter for?
My lords, it is with regard to a complaint has been filed before the magistrate under section 200 of the CRPC.
Let me see that order. What is it? You are for the opposite party.
For the informant, Your Lordship, on behalf of Mr. Rajesh Kumar Mahapatra.
Okay.
I pray for a passover, Your Lordship. He is on his legs.
So it will be taken up next week,
There is
14th August.
there is an interim order, that's why.
That is continued till next week. 14/8. A submission is made on behalf of Mr. Devasis Panda, Land and Council, appearing for the appellant to take up this matter next week. Land Council for the opposite party respondent number 2 is present. List this matter on 14/8/2023. Interim order dated swan so shall continue till next date. Yes.
Published.
Item number 47.
Bail, my lord, last time your lordship direct to file comprehensive affidavit, my lord.
कौन करथिली?
Comprehensive affidavit, my lord.
How many cases you have got?
7 cases, my lord. All cases he has been released on bail, due to the mining activity in local area, my lord. The petition and other villages are protested, for which.
So what is this case about? Offense here is
307, my lord.
yeah.
307 is made to one Rajesh Maharana, son of the petitioner.
Who is the injured?
Injured, my lord, Surya Sundhi.
Jhadeswar Sundi, my lord.
Jhadeswar
Sundi.
Sundi.
Yes.
One injured.
One injured, man.
What sort of injuries he has received?
My lord, injuries on
belly, man.
Lacerated wound, my lord. Simple.
Nature of injury is simple.
My lord. Another is grievous, my lord. A stab wound over left lower rib.
Okay, that has been opined to be grievous in nature.
Grievous.
He has been discharged from the hospital.
Yes, madam. This is. Father
What is
and
that?
son, my lord, both have father and son assaulted the injured by means of knife and a lathi. He assaulted by means of lathi.
Who?
Petitioner.
But what about the father?
My lord, he is the father.
Oh, he is the father.
My
Okay.
lord, son assaulted by means of a
Lathi, but
no knife.
knife.
My lord.
Son, what about the son?
He has been not arrested, my lord.
Not arrested.
My lord.
So son by knife, right?
Yes.
And petitioner by lathi.
Lathi, my lord.
So about so far as lathi blow is concerned, that is simple in nature.
That is, my
You
lord.
said just now that
Laceration wound, my lord.
the knife blow has been opined to be grievous in nature.
Grievous in nature. Stab wound, that is.
And the injured has been discharged from the hospital.
Yes, madam.
Any criminal antecedent?
7 criminal antecedents.
Oh, that there. And now you are in custody since when?
Since 20th April, ma'am.
20th April.
Yes, ma'am.
Charge sheet submitted.
Yes,
Charge sheet submitted.
File where is that a comprehensive
I
affidavit?
have filed them.
A comprehensive affidavit achieved. All right. What is that last order? All right. In pursuance of the order dated 18/7/2023, the Land Council for the petitioner, appellant, has filed the comprehensive affidavit relating to the status of the criminal cases instituted against the petitioner. Copy of the same has been served on the Land and Council for the state.
Yes, yes.
The Land and Council for the appellant submits that appellant is in judicial custody since 24/2023 and he has been charge sheeted under section
307.
देखिए कौन तो ठीक से
Madam. 294,
294
341,
341
323,
323
324,
324
307,
307
34 IPC.
34 IPC
My lord, 31
31
and 32B of SST.
31 and 32B of SCST Prevention of Atrocities Act. It is further submitted that the prosecution case is that the injured Jhadeshwar Sundi was assaulted by the appellant and his son. So far as the assault part is concerned, and so far as the accusation against the appellant is concerned, it is stated that he assaulted the injured by means of a lathi, and the injury sustained by the injured for such assault has been opined to be simple in nature. Land Council submits that in view of the available material on record, the bail application may be favorably considered. The Land Council for the state placed the statement of the injured Jhadeshwar Sundi and submitted that the son of the petitioner gave knife blow to the injured, and the medical examination report indicates that the injury is grievous one, and further submit that the son is absconding as per charge sheet. Charge sheet absconded देखो जी ना? Abscond. Considering the submission made by the Land Council for the respective parties, the nature of accusation against the petitioner, since the injury alleged to have been caused on the injured due to the overtact committed by the appellant, is simple in nature. Further, taking into account his period of detention in judicial custody, I am inclined to release him on bail subject to condition he shall not try to come in contact with the injured and shall not threaten any prosecution witnesses, appear before the Land and Trial Court on his state violation of any terms and condition shall entail cancellation of bail allowed. That part you have mentioned that notice is made sufficient, will you? The date 17th July notice has been made sufficient on the informant, non-appears for the informant. Okay.
Item number 56.
This is SCST appeal for bail, my lord.
Notice sufficient?
My lord. Notice.
When?
No, my lord, no service receipt has been received. Service receipt has not been received. Case diary has been received.
ଗୋଟେ ସପ୍ତାହ ମିନିମମ୍ ତାଙ୍କୁ ଦବାକୁ ପଡିବ, ତେଣୁ ଆପଣ ସେଇଥିପାଇଁ ମୁଁ ଡେଟ୍ ପଚାରୁଛି।
My lord, my lord.
ତାଙ୍କ ଉପରେ ନୋଟିସ୍ ସର୍ଭ ହବ, ଗୋଟେ ସପ୍ତାହ ପରେ ଯାଇ ମୁଁ ମ୍ୟାଟର ଟେକ୍ ଅପ୍ କରିବି। ତେଣୁ you have not received any instructions.
My lord.
And what about the case diary?
Yes, my lord. Case diary is available, but service receipt I have
What
contacted.
is the offense here?
Offense is, my lord, 354. Charge sheet has been filed. My lord, 452, 354, 294, 323, 506, 509. PSC. And during investigation, he was complied the notice under section 41A of CRPC, my lord. And thereafter.
But that information should I should mention it. That is the main problem.
Yeah. Keep it to next Monday, my lord.
All right. The learned counsel for the state submit that he has received the case diary, but the intimation regarding service of notice on the informant is awaiting. The matter will be listed next week. List this matter on 14th August 2023. Yes.
As he stated, I contacted the IIC. He stated the informant was out of station, for that he could not serve.
Okay, try to serve.
Monday,
next Monday. Somebody, if it is absent, then there is provision. If you serve it on an adult male member of the family, as per section 64, it would be deemed to be.
What he stated, my lord, her father is also in ICU. For that, their family members are also out of station. She stated she will return on 9. For that,
you see, informant will not definitely come here.
Yes,
may come, he may not come, or he may engage any counsel. So
she requests to be noticed, and she may take recourse of any agency of engaging there.
64 CRPC says that where a person sworn so by exercise of due diligence not found, then the summons can be served by leaving one of the duplicates with some adult male member of the family. So, all right, next.
Item 61.
appel and seeks for an adjournment. Adjourn 2 সপ্তাহ পরে পকে দেন।
Item 65.
Your Lordship, kindly allow me to submit virtually.
Yes.
Your Lordship, will kindly allow me to submit virtually, Your Lordship.
এই ভলিউম बढ़ावे শুভুনি। Yes, you can argue the matter, Mr. Roy.
65, my lord.
Your Lordship, this is an
65, 65.
65. Yes.
65, my lord. Case diary and service receipt has not been received. Lordship.
Okay, it is from which police station?
Khalli Court.
Khalli Court.
Yes.
So get it, we will take up this matter next week.
Next week.
Your Lordship, please, may I submit the co-accused person's bail order? Your Lordship may keep it in record.
Yes, yes.
Bail order of co-accused person, Your Lordship may keep it on record. My friend is there to submit the bail order of co-accused person. Your Lordship may keep it on record. Let the matter.
Who will give that bail order?
Your Lordship, my senior friend is there in the court.
The learned counsel for the petitioner filed the copies of the bail orders of the co-accused persons which are taken on record and give a set so that if you are claiming
Maybe
parity, the state council will verify.
Maybe
Yes,
case
Your Lord.
diary available with that record, my lord. I will be.
Okay. The learned counsel also supply the copy of the bail orders to the learned counsel for the state in court, who seeks some time to obtain the case diary and also instruction about the service of notice on the informant. Place this matter in the week commencing from 14th August 2023.
Grateful, Your Lordship.
Yes.
21st August.
You want 21st?
No, Lordship directed.
I directed it to be listed on 14th because you have already sent it.
Yes.
It
Already
is to,
sent. Already.
suppose it has been earlier served.
Right.
If it is recently served, then obviously another week
Right.
will be granted.
Right.
But if it has already been served, but you have not received the instruction.
Right.
Yes.
Item number 66.
May I please, Lordship?
Yeah.
Appellant custody since 16
Lordship has issued notice.
What is it?
Notice was issued, my lord. Cassited offense under section 302, 120B, 34 IPC.
No, let the notice কথাটা কোন?
Yes, ma'am. Has received the notice on 24th July, ma'am.
চলিব সপ্তাহ হয়ে গেলানি। So this is item number 67. Notice sufficient. Custody date.
My lord.
Custody date.
Custody 18/6/2023.
Charge sheet under section
302, 120.
Charge sheet
120B,
number 302, 120B, 34 IPC, read with section 32B of SC/ST Act.
32B and
32B, only 32B.
only yes.
Ma'am.
Yes.
That is
so, who is the deceased here? What is the name?
Rabi Singh.
Rabi Singh.
Date of occurrence.
Date of occurrence, my lord, that is 17
18/12/2021.
18/12/2023. 2021.
Yes.
As per the FIR story, my lord, there is no allegation against the present person. Only they have stated that there is a previous enmity with the Rabi Singh 2020, for which the Rabi Singh and his brother have gone to the jail custody.
What is your name?
Sheikh Haider Ali.
It is that Haider of Kendrapada?
No, my lord. It is Baleshwar.
Okay. Your name is there in the FIR.
FIR, that is the previous dispute by 2020. At the time of participation, he was not there. Only 4 persons they have participated. With regard to murder, Mahbub, Sheikh Ramjan, Sheikh Subal, and Sheikh Kala.
No. This in the FIR, your name is there. So
name is there. I'm reading out there. What is the implication?
No. What I'm telling you that is there any eyewitness to the occurrence?
Yes, madam. Madhav Singh.
Tell name the one eyewitness.
Madhav Singh, madam. Madhav Singh lost the FIR, madam.
All right. Madhav Singh's 161
yes,
statement,
madam.
please.
I have.
Hey,
Incident he was not.
এটা কোড কি কো কপি এটা পাইলে এটা কি দিলা মোর নাম মাধব সিং বয়ান ଏଇକି ଦଉଛି ଯେ ଗତ 2020 ମସିହାରେ ମୋର ଭାଇ ରବି ସିଂ ହେଲା ଡିସିଜ୍ଡ ଓକେ ଓ ତାର ସୋଆନସୋ ଗ୍ୟାଙ୍ଗର ଏଇ ମାନେ ମାରପିଟ ହୋଇଥିଲେ ତ କେସରେ ମୋର ଭାଇ ରବି ଓ ହାତୀ 2 ଜଣ ଜେଲ ଯାଇଥିଲେ ଜେଲରୁ ବାହାରିବା ପରେ ସୋଆନସୋ ମାନେ ମିଶି ଗ୍ୟାଙ୍ଗ କରି ପୂର୍ବ ଶତ୍ରୁତାକୁ ନେଇ ମୋର ଭାଇ ରବି ସିଂ ତାଙ୍କର ସହିତ ହାତୀ ସହିତ ପଟି ଓ ହୁସେନ ହାଇଦର ଅଲି ନାମରେ ମାରପିଟ ହୋଇଥିଲା ଏବଂ December 13 date of occurrence ଟା ହଉଛି କେବେ? What is the date of occurrence in this case?
18/12/2021.
ଆଚ୍ଛା ଗତକାଲି ସକାଳେ ସମୟ 7ଟା ବେଳେ ଖବର ପାଇଲୁ ଯେ ସୋନସୋର ଗାଁର ଲକ୍ଷ୍ମୀ ମୋ କେମିତି ରବି ମର୍ଡର କରିଥିଲେ।
The lordships, I have given the order that has been reflected in the orders. CRA.
No, from you got that the petitioner has not assaulted that part.
Yes.
Who kaha statement who?
The Madhav Singh statement.
नहीं तो किसी अरे
No,
कोड़ा
Lordship.
मार्क करना दी कौन? Please mark that portion where the assault party stated.
The Lordship has passed the order, my lord, that has been reflected.
Please, I'm seeing that
Yes.
eyewitness statement. You have to mark that yes, you are not being named by the eyewitness as the assailant of the deceased. Matter
Yes.
ends there. Mr. Mahapatra,
Yes.
is it so that Madhav Singh has not implicated the petitioner to be the assailant?
Assailant is Yusuf.
Yusuf.
Okay.
Another,
Where is that bail order?
but they had hashed the plan. May I read the statement of another witness, my lord, who was present at their meeting, and petitioner was there along with to commit murder of that deceased, my lord.
What
And
about the criminal antecedent?
criminal antecedent, he has no antecedent. He has no.
The informant is one Madhav Singh, who is an eyewitness to the occurrence. He has specifically stated that 4 accused persons, namely Mabud, Sheikh Ramjan, Sheikh Subhan, and Sheikh Lala, got hold of the deceased, Rabi Singh, and
Yusuf Asad.
accused Yusuf
Dealt with the knife.
dealt knife blows on the deceased repeatedly. As a result of deceased died. Okay.
The statement of Rabindra Hasanta, my lord.
Yes.
ଆଜି ତିରଖରେ ଦଉଛି ବୟାନ ଦଉଛି ଗଳିପୋଲ ବସ୍ତିର ରବି ସିଂ ଶେଖ ମାମୁଦ ଓ ଉଭୟଙ୍କ ପରିବାର ଲୋକଙ୍କୁ ମୁଁ ଭଲରେ ଜାଣେ। 2021 ମସିହାରେ ରବି ଓ ତାର ସାଙ୍ଗ ହାତୀ ଓ ମାମୁଦ ଗ୍ୟାଙ୍ଗର କଟି ଓରଫ ଶେଖ ହାଇଦର ଅଲି ପିଟିସନର ମଧ୍ୟରେ ମାଡପିଟି ହୋଇଥିଲା। ସେ କେସରେ ରବି ଓ ହାତୀ ଜେଲ ଯାଇଥିଲେ। ସେ ଦୁଇ ଜଣ ବେଲ ଆସିବା ପରଠାରୁ ମାମୁଦ ଗ୍ୟାଙ୍ଗର ପିଲାମାନେ ସେମାନଙ୍କ ଉପରେ ପ୍ରତିଶୋଧ ନେବା ପାଇଁ ସୁଯୋଗ ଖୋଜୁଥିଲେ। ତା 18/12/2021 ଶନିବାର ସକାଳ ପ୍ରାୟ 6:45 ହେବ ମୁଁ ଗଳିପୋଲ ବସ୍ତିରେ ଦେଇ ନୂଆ ବଜାରକୁ ଯାଉଥିବା ବେଳେ ଦେଖିଥିଲି ଗଳିପୋଲର ମାମୁଦ ଘରେ ମାମୁଦ ଓ ତା ମା ଜାବେଦ ବିବି ଓ ତାର ଭାଇ ଶେଖ ୟୁସୁଫ, ଲାକି ଓରଫ ସତ୍ୟ ଜେନା, ସିପୁ ଓରଫ ପ୍ରକାଶ ରାଜ, ଶେଖ ସାଦିକ, ଲୋପା ଓରଫ ଶେଖ ସଲାମତ, ଶେଖ ସୁଭାନ, ଶେଖ ଲାଲା
Upon conspiracy part katha
Yes,
kouchati.
my lord,
But
conspiracy.
these persons were also there.
Yes.
Sheikh Sabawat and Sheikh Amir Hussain.
They were there.
So they have been released on bail. What he says, he is claiming parity. He says that assault, so far as assault party is concerned, that is specific against 4 persons.
That was not there. Yusuf had assaulted.
Right. Other part that is there, and you say that there is no CA. Or the Learned Council.
The dispute, the assault that was with regard to the earlier assault on the present petitioner. That is the
Or the Learned Council for the petitioner and counsel for the state. The Learned Council for the petitioner submitted that the petitioner is in judicial custody since 18/6/2023. He has been charged sheeted under section 302(120)(b)(34) of the Indian Penal Code, section 32(b) and of the SC/ST Act. The occurrence in question took place on 18/12/2021. And the informant is one Madhav Singh, who is also an eyewitness to the occurrence. and he has specifically stated that 4 accused persons, namely Mabud, Duire Sheikh Ramjan, Tinela Sheikh Suban, and Sheikh Lala, foretold of the deceased Rabi Singh and accused Sheikh Yusuf dealt knife blows on the chest of the deceased repeatedly, as a result of which the deceased died. Land counsel for the appellant submitted that some of the co-accused persons, namely Sheikh Shekhawat and Sheikh Amir Hussain, have already been released on bail by this court in CRLA number 387 of 2022 and 314 of 2022 respectively, by common order dated 12/9/2022. And he files the copy of the order which is taken on record and submits that the bail application may be favorably considered. Land counsel for the state oppose the prayer for bail, place the statement of the informant Madhav Singh, however, doesn't dispute that there is no criminal antecedent against the petition. The Land Council submits that though there are material on record relating to conspiracy part, but he fairly submits that similar allegation is also against the co-accused persons Sheikh Shekhawat and Sheikh Amir Hussain, who have been released on bail. ତାପରେ ଯୋଉଟା ନାଦି ଚିହ୍ନଟା ଦେଇଛି ବେଲ୍ ପୋଷଣ ଇନଫର୍ମାଣ୍ଟର ଇଏଟା ସେଇଟାକୁ ଏଇଟା କରିଦେବେ ସବମିଶନ କରି ବେଲ୍ ଆଲାଉଟ୍ କରିଦେବେ ହେଲା। ଏ ଯୋଉ ଇନଫର୍ମାଣ୍ଟ ତ ଆଜିରେ କି ଆପିୟର କରୁନାହାନ୍ତି, ଏଇଟା ଷ୍ଟେଟଙ୍କର ସବମିଶନ ଲେଖିଦେବେ ହେଲା। ଏ ଯୋଉ ଷ୍ଟେଟର ସବମିଶନରେ ଲେଖିଦେବେ ହି ପ୍ରେଜ୍ ଦି ପୋଷ୍ଟମର୍ଟମ ରିପୋର୍ଟ which indicate that so and so ହେଲା। Yes, next.
Item number 68.
Item 70, let's say, is a fresh matter. Notice to be issued.
69.
SC/ST Act.
So, serve an extra copy by tomorrow. Okay. Extra copy, usual order, notice, CDCA.
69 has not been called, my lord.
69 is that matter which will come along with item number 52. 69 and 141 also. These three matters, just note it out.
Sorry.
So that you just mention in that file that it is connected to CRLA number 594 of 2023. So that, yes. Next.
Item 71.
71.
Miller's item 71 is under SC/ST Act. Miller's notice has to go.
Notice has to go. Serve the extra copy by tomorrow.
Miller's.
Notice CDCA.
Miller's 74 same.
Same.
Miller's. Notice has to go, Miller's.
All right.
73 same.
73 same.
Same.
All right, extra copy by tomorrow.
72 also same.
Notice CDCA. 72 same.
Milo.
All right, extra copy. Notice CDCA.
151 Millards, just for your information, Millards, item 71 is related to today's item 130, Millards, which is pending, and CD may be there because your lordship has already installed.
No, it's CD is all right, but what about
Millards,
the notice?
Millards notice.
Okay, yes, next.
Item 75, your lordship.
Yes.
Fresh matter.
Which one?
Item 75.
75, some defect is there, let us see.
I have already complied, your lordship.
Just let me see that what is that defect. 5E says
Advocate welfare I had not paid.
No. 75, this is 791. Click. So is it then 7915E? 51 तो किसी नहीं अच्छी अब এটা কোটা করা কোন জেরক্স করে স্ক্যানিং सेवन नाइन वन ऑफ 2023 यू आर एटा जो एटा जेरॉक्स ହେଇଛି जो स्कैनिंग ହେଇଛି 791 ऑफ 2022 ର ତାଙ୍କୁ ଏଟା ଠିକ କରେଇବେ ହେଲା ଦେଖି ସେଟା କଣ ହେଇଛି हाँ 50 ଟଙ୍କା ଦେଇଛନ୍ତି
ଆଜ୍ଞା I paid it on 31st.
All right, though defect number 5E has been shown to be the sole defect, but the Learned Council for the Appellant submits that the defect has been removed
on 31st.
On
31st 7.
On 31/7/2023. Let the registry verify the same and report. Stop. Extra copy we saw. Is a 360 matter.
Okay.
Extra copy by tomorrow. Notice CDCA. Yeah.
ଆଜ୍ଞା ଆସିଲେନି
item. I got a matter.
Item 76.
Malad, this is also SC/ST matter, Malad. Notice has to.
Okay, extra copy. CDCA. Okay, 63. You are who is the? You are there. Come. You are for the informant.
Yes, sir.
Okay. Mr. Mahapatra, you will do this matter. Yes. Sarthak Naik is not there. Which item?
246, my lord.
Is a case of conviction.
Yes, my lord.
What is the sentence import?
Well, 4 years, my lord, conviction, my lord.
So bring it tomorrow in the supplementary list.
Item 1 to
Just a minute, let me mentioning a matter. Two 46, Mr. Rautrai.
My lord, my lord.
The defect is not removed. You said that it has been already served.
Copy is out. The receipt
All right,
is with me,
Mr. Rautrai, এটা লিখি দিন। Mr. Rautrai, এটা ঠিক করে দেবে আগুটি, huh? Mr. Rautrai, learned counsel for the appellant submits that copy of the appeal memo along with the annexures have been served on Mr. Sarthak Naik, and special public prosecutor.
The receipt
for
is with
the
me, my lord.
CBI, huh?
The receipt is with me.
And is having the receipt. Release this matter tomorrow, that is 9th of August 2023, for orders indicating the name of Mr. Sarthak Naik, special public prosecutor, in the cause list. So it will come tomorrow in the supplemental list 9/8/2023. Okay.
item 127.
Yeah.
Conversion, I filed inadvertently.
Just a minute. 127,
your lordship. I have already filed an IA.
127, change of nomenclature allowed.
Yes, your lordship.
It will be listed before the assigned bench. Okay.
That's
IA disposed of conversion. Okay.
151 fresh SC Act lordships, like notice.
Which one? Which item?
151 lordships.
151. Just a minute. It's a fresh item.
Yes, madam.
SC/ST matter.
Yes.
All right. Notice be issued. You serve the extra copy
Tomorrow lordships.
tomorrow, and CD, CA to be obtained. Mr. Mahapatra, take note of it. Item 151. All right.
Lordship, item 82, paper book is already received, my lord.
Just a minute. 82.
Hmm.
82, what do you want?
No, paper book already received, my lord. Noting is there. One IA is pending for yearly hearing of this matter, my lord.
2015.
My lord.
What is the offense here?
304B, my lord. 304B, 498A, 34.
All right, it will come. Obviously, it will come next week, and it
Next
will
week in
go.
hearing matter, my lord. It is comes in a order. Order list रे आसीजी, hearing list रे आसो, paper book receive ହେଇଛି.
All right, paper book has already been, this is item number 82. Paper book has been received. Let a copy of the paper book be supplied to the Learning Council for the state. Since criminal appeal is of the year 2015, matter be added to the hearing list. From the week commencing from the king, okay, बताओ है ना? हाँ तब ऐड कर दो डेट देख नहीं डेट टा कोई दो तो उसी पकड़ देवे है ना सो दिस मिसकेस इज डिस्पोज्ड ऑफ ये जो अर्ली डेट ऑफ हियरिंग ना तो डेट पकड़ देगी डिस्पोज ऑफ कर दो सो डेट फिक्स्ड हूँ लिख दो इसका लिख है ना यस
My lord, item number 51. Several matters.
51 is what do you want to
I find the bail application in respect of the
51 notice sufficient when it was sufficient
My lord, that is on 23rd July.
23rd
July.
Since when you are in custody?
Since from 2021.
No, tell me the date of your custody. Is it mentioned in the final form? Date of custody must have been mentioned if it.
arrested on, forwarded on 29th July. 29th December 2020.
29/7
29/12 में
29/12
2021.
2021. Okay. What are the offenses under which charge sheet submitted?
Charge sheet file on sectional 376 2I
376 2I. Yes.
2N.
Yes.
Read with section 3 2B of SC/ST PO Act.
So the victim has been examined in the trial court.
Yes, my lord.
So where is the statement of the victim?
Victim
Have
statement of the
have you filed it?
yes, sir. Yes, my lord.
No, only copy not shown.
Where is that? We couldn't find it. 11 to 14 is the FIR. Then rejection order is 15 to 17. Then your Okalatnama is there. Where is the statement of the victim? Evidence of the victim. To whom you have given, London Council? The London State Council also says that he has not received the copy of the evidence of the victim. She has been examined as PW?
PW 3, sir. 3 here, my lord.
So, give if it is available with you, the system assistant is there. So send the copy to this court so that it will be handed over to the London State Council. The system assistant, please hand over the certified copy of the deposition to the system assistant. It will be forwarded to this court, and this court will hand over the copy to the State Council. And this matter will be taken up next week on 14th. Okay. The London Council for the State submits that notice on the informant has been made sufficient on 23/7/2023. Mr. Asit Kumar Ota, Land Council, appearing from Virtual High Court, Moyurbhanj at Baripada, submitted that the victim has already been examined in the trial court as PW 3, and he will file the deposition copy of the victim, giving copy to the London Council for the State. Place this matter on 14th of August 2023.